Well, good afternoon. Good afternoon. It was a stimulating morning. I'm still trying to process a lot of it. I was telling Lindsay and Sherrod that charts and tables are not pictures to trial lawyers. So you got to go easy with some of the data. Sort of break it down a little bit. I've always told Baumgartner that the stuff that he brings is really transformational, and that we've got to figure out a way of getting that to the right audiences. When I think about social sciences and the contributions it's made, Dave Baldus's name was mentioned in the morning. He's just a heroic figure. I think the next level is providing the information that we're now getting on the patterning of the death penalty, the counties and states of where it's used and how it's isolated and how, in truth, the death penalty has been abandoned. And we've got the facts on our side. And so many times where this debate is engaged, the response does not meet the facts. The response comes with the rolling out of crime scene photos. It's an appeal to the irrational histrionics. And to the extent we can move the facts closer to, the debate closer to the facts, rational people can understand and be moved and be persuaded. This afternoon session, I think, in some ways, the planners at the Journal was thinking, let's bring some conflict in. So this is the blood sport part of the symposium. In the red corner we've got, and in the blue corner we've got so and so. And so the build-up is this is where we get some engagement in conflict. I think it's kind of remarkable that at the end of the day, you're going to see very little blood on the floor. And some of the differences, at some level is going to, I think, narrow down. But let's not start there. Let's start with the drama. Doug Berman, Professor Berman, is and produces one of the most, if not the most respected, criminal law sentencing blog informational source in the country. I know at the Federal Defender, we are a pretty insular community. We don't look outside the defense community, but one place we do look is the Berman blog. And he's in one corner. In the other corner is Professor Malone, who, in the spirit of Scalia and Alito and Thomas, might be a castaway. She actually is concerned about the world outside of our borders, has thought and engaged a lot with the world, and thinks that the world view, the global view, has something to contribute to this discussion. And I think we're going to listen from these two perspectives. And if I would say the inside game is Berman's game, he is the prototypical criminal justice professional. He sizes himself up as the honest broker, and he's going to deliver that point of view. And Doug, why don't we start with you?
Very good. And is it okay for the camera thing? I'll just stay here, both because I look taller when sitting down and I'm kind of comfortable. And so, and that's me, realpolitik at every stage. And what I'm eager to highlight here is the byproduct not only of my own longstanding reflections of uncertainty about my own views about the death penalty and what I perceive to be the realpolitik of the death penalty, probably the realpolitik that's been around for decades, but that is important to keep in mind as we think about the future of the death penalty after Glossip. And here I start by going back to an opinion, McCleskey v. Kemp, that I think was referenced recently, because I think everything about everything can be found in that opinion, and that's in fact a broader congratulations and thank you to the organizers of all of this, because you can't spend too much time obsessing over the death penalty as a lens to our entire political system, a lens into so many aspects of law, both in theory and in practice. And so I love talking about it, I love thinking about it, and I love particularly thinking about Justice Brannan's comment in the dissent in McCleskey v. Kemp. That was the '87 ruling by the Supreme Court that looked at the Baldus study. To its credit, to some degree, said, we'll assume the statistics are right in the Baldus study. We'll assume there is statistically provable racial disparity in the application of the death penalty, but that's not intentional discrimination, so therefore it's not an equal protection problem, and we don't think that showing of statistical discrimination, so to speak, statistical disparity amounts to an Eighth Amendment problem. It's not cruel and unusual punishment, and the last few paragraphs of the majority's opinion is what's so central to their concerns. It's a slippery slope concern. They say if we strike down the death penalty because of racial disparity, we'd also have to strike it down because of gender disparity, or they don't say baldness disparity, but that's the other one that it appeals to me in a variety of settings. And they say, oh, by the way, the Eighth Amendment doesn't say anything only about the death penalty, so if we strike things down based on disparities related to the death penalty, we would, this is the quote, open the door to widespread challenges to all aspects of criminal sentencing. And I think they're right that it would be challenging to draw a line at death or draw a line at race, but Justice Brannan brilliantly says, in response to those slippery slope concerns, on its face, such a statement seems to suggest a fear of too much justice. And in a symposium I helped put together back at my home law school about McCleskey versus Kemp, after a while, I resonated on that idea, this fear of too much justice, because I think it's a brilliant response to that concern. His point being, look, if there are all these disparities, if there are all these problems, that's not a reason not to address it in this case. That's a reason to go after it in all these other settings as well. And I think there's a lot to that. However, in this setting, what I want to highlight, that after spending time watching a lot of death penalty reform debates, myself being involved in a 2-year task force at Ohio to improve the administration of the death penalty in the great state of Ohio, I've concluded that almost everybody seriously involved in advocacy and debates over the modern administration of the death penalty actually has, and in some sense justifiably has, a fear of too much capital justice. And my goal, what I'll try to do better in the full paper, what I'll try to do here in the next 15 minutes, is to unpack what I'm saying there, what I think is the practical reality, that both proponents of the death penalty and opponents of the death penalty fear too much justice. And I want to suggest, in some sense, that it's perfectly legitimate in light of their own commitments, philosophically and practically, that they should fear too much justice. But the point of emphasizing this is it leads me to the conclusion, a conclusion that I sat through lots of meetings, not quite tearing out what little hair I have, but being frustrated when our mandate on the Ohio Death Penalty Task Force was not to talk about ending the death penalty in Ohio, was only to talk about how we could improve the death penalty in Ohio. And because I saw both through that task force's work and in other debates about the death penalty, that that's a failed enterprise when all of the most passionate advocates don't want improvements in the death penalty, that we're inevitably going to have real challenges with fixing the system. And it really leads me, and it's sort of a preview to my own partial support from a weird practical perspective, that maybe we do want the Supreme Court to strike it down, right? Maybe in a weird, bizarre, almost kind of Marshall hypothesis kind of way, the Supreme Court ought to say, we can't trust the political processes to do better because all the people who really care about the political process don't want to do better. And I'll try to explain that a little bit more. And really, this is all just a long-winded gripe of I wasted 2 years of my life trying to make Ohio's death penalty better. And I have here the 56 recommendations that our task force produced over those 2 years. This is just the list of the recommendations, which runs 25 pages or so, and then there's a 75-page report that goes with it, including the dissent to the report. And the key, what I have here, which I guess if I was smart I'd have it up on a slide, is we have what's happened to those recommendations in the General Assembly, and basically it says nothing, 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 nothing all the way down. So 2 years of work was something of a fool's errand, though I'll end at the end saying, well, maybe it wasn't a fool's errand, so I'll hopefully that's where I'll end up in the 15 minutes. But let me give the backstory, not only of why I think too much capital justice is unlikely in modern times, but really unwanted, right? So part one of this is the practical argument of fallibility. A perfectly just death penalty system is practically impossible for fallible, and I'll put in parentheses here, and politically sensitive Americans to create and maintain, right? So that's a little bit of a story of inevitable human error, but it's actually a lot of a story of modern democracy, modern politics. I might even pick up on Henderson's point that the appeal to emotion, bringing out the pictures of the people killed, is always going to have a kind of political resonance in a democratically marshaled society in a way that, whether we want to admit it or not, is going to, every pun intended, move the needle differently than rational conversations that we're spending all day talking about. So part one of this is we're fallible humans, we're going to have mistakes, mistakes of convictions, mistakes of death sentences, inequities in the patterns of what death sentences are pursued, but I think those are much more a story of modern politics and the dimensions that surround modern politics in America that I don't think is changing much anytime soon than it is about our fallibility. I can talk a lot more about the fallibility issue, but most people who particularly are against the death penalty are keen to accept that premise. They're not going to push back on that idea that we can't always get it right and will actually almost inevitably get it wrong in some ways. This is the more controversial point. This is where the blood sport comes in, perhaps. This is the point that I want to emphasize both theoretically and practically. My sense is very few persons, maybe none other than me, actively involved with or concerned about modern death penalty systems are genuinely interested in making these systems ever more perfectly just. And then the last piece, which is also depressing, is the vast majority of citizens, the vast majority of democratically elected lawmakers don't really care about all of these particulars, right? They aren't here to hear all of this where we're talking about how the system's unjust. They have better things to do with their lives, in part because the death penalty is a tiny part of our modern justice system, and I'll talk a little bit about that more. But I really want to unpack what I think is both the most controversial and, to me, the most important insight I'm trying to develop here, which is the disinterest among both robust death penalty opponents and robust death penalty supporters for having a system of more perfect justice in capital cases. Part one is, and people in this room I hope will take issue with me if they don't agree, for opponents of the death penalty, at least most opponents of the death penalty, the very concept of death penalty justice is an oxymoron. It's a contradiction in terms. There's no such thing as justice when the state is in the business of killing. And to the extent that you accept that, and some people accept it from a moral perspective with religion involved, some people accept it without a moral perspective with religion involved. Obviously, Kant saw it exactly the other way. We heard earlier today. The key point is, if you buy the idea that any act of state killing is unjust under any circumstances, any time, to have a conversation about improving the death penalty necessarily goes on your opponent's ground. It suggests the possibility we could have a just system, and that's a possibility that already puts you behind the eight ball in moving the system to what you think would be a truly just system, i.e. a system without the death penalty altogether. So part of it is a theoretical commitment. I won't say that every abolitionist embraces this theoretical concept that the death penalty is per se unjust, no matter how administered or how it goes. And in fact, what's interesting in modern political times is the very convenient moderate position, especially among Democrats. We hear this from President Obama. We hear this from Hillary Clinton. We haven't quite heard it from Bernie Sanders, but I think he still articulates his disaffinity for the death penalty in this way. Well, I might be for it in theory, but seeing how it's applied, looking at everything we saw earlier this morning, that leads me to think the game's not worth the candle. And that's itself part of the story that the bold Sister Helen Pragen abolitionist, it's just morally wrong to do it, hasn't sufficiently gotten us to abolition. And so, but still, the point is, and the point I'm trying to make is that death penalty opponents are concerned just theoretically from even talking about making a capital system more just. That's a contradiction theoretically in terms. More practically, and this is to some extent Carol Steiker's point, it's another realpolitik point, the more you improve capital systems, the more you ensure adequate defense counsel, the more you ensure racial disparities don't influence the application of the death penalty, the more you ensure that truly the worst of the worst are the only ones who are subject to capital prosecution, the more you make the public think this is working pretty well, right? And the most obvious example of that, and it's an obvious example that Austin Surratt, to his credit, although I keep trying to find where he said this, maybe he deleted it already, abolitionists shouldn't talk about the Tsarnaev Boston bomber case because that's so unrepresentative of all the things we know about capital punishment, right? That's a case in which there was more than adequate defense counsel, where it clearly seems that the nature of the crime, not the characteristic of the defendant, although you could go down that line in a bunch of different ways, perhaps, and that the process was run, as usually the federal death penalty process is run, as fairly as one could reasonably hope if you're going to have the death penalty. Now, people can take issue with that, or more accurately, Tsarnaev on appeal is going to be taking issue with that in a variety of kinds of ways, but Austin Surratt said, and I think it's not wrong for him to say, those of us in the abolitionist community, and he coined this term, new abolitionism, where people are making arguments for abolition based in poorly operating justice systems rather than in a blanket moral opposition. He said we shouldn't talk about that case because it's not representative, and even more importantly, it's hard to get people to understand how bad the system is when you focus on that case rather than the cases we focused on so far this morning. And I think it's telling that I'm the first one who's brought up that case. I would say, among other things, that that's by far the most widely known capital case among Americans today. It's certainly the most widely reported capital case among Americans today, and I think it will persist as the case that may make it awfully hard to get Justice Kennedy to get behind a blanket prohibition of the death penalty, because that means he gets off of death row. And for no other reason, because we don't want to execute other people, but it seems like we want to. I won't say we all want to, but we want to execute him. This is really Carol Steiker's broader point about the harm that the Supreme Court has done with its regulation of the death penalty. She says it's entrenched us. It's taken away the most egregious cases. It hasn't taken away the innocence problem. That's a whole other conversation. But it's taken away now the kids sentenced to death at 14. It's taken away the intellectually disabled sentenced to death, although not really, as we know, and so that's itself part of the story, as we haven't lived up to the Supreme Court's jurisprudence. It's narrowed. This is a point not to be lost. It's significantly narrowed the range of people who can be subject to the death penalty. We don't have rapists subject to the death penalty, where we would have even wider, much more robust disparities in who was getting the sentence or not. Right? So the statistics that we see this morning would be that much more profound if we had the 1 or 2 or 3 child rapists out of the literally hundreds of thousands we have in this country on death row. And so in many ways, the very process that the Supreme Court has engineered, really being the only body that goes about trying to mend rather than end the death penalty, has entrenched it. And I think will continue to entrench it in modern America. And I think that's why Austin Surratt's right to say, I think any abolitionist is right to say, we're not going to get where we want highlighting the problems with the death penalty when we look at a case like the Tsarnaev case, where those problems aren't front and center. And of course, the parallel to that is, if you really were just about improving capital justice, the talk after the Tsarnaev case should be, how can we make sure every capital case is like this? How can we make sure that every defendant charged in any jurisdiction with any crime that carries the death penalty gets Judy Clark and all the lawyers that come along with Judy Clark, gets not just adequate representation, but gets the very best representation? And we might say, well, we don't talk about that because that's impractical. Okay, it might be impractical, but if you really were committed to fixing the death penalty, you wouldn't avoid talking about the Tsarnaev case. You'd emphasize the Tsarnaev case. You'd emphasize that that shows the system can be run as fairly, maybe not perfectly fairly, but pretty darn well, and let's not allow any other system to do anything but that. Right? And this is actually part of my own little bias to say, if we really want to be strategic about trying to get rid of the death penalty, we should try to get rid of it in the states and preserve it in the federal system. That's another part of the Tsarnaev story. Of course, there's the other side of this coin, and especially because now I'll be preaching to the converted. Capital prosecutors and ardent supporters of the death penalty, they also don't want too much justice. Why? Because Dale Cox told us, I want to kill more people. We don't kill enough people already. I don't want real justice. I want more vengeance, right? I won't call it retribution, right? Because I don't think when your attitude is, I want more people dead because it's a jungle out there, it's about retribution. I think it's fair to say that's about vengeance. It makes me feel good. It makes other people feel good when we kill the killers. All right, if you're a student of Kant, maybe you can tell me it's retribution, but I think at the end of the day, it makes me feel good killing people, especially the people who have killed us. right? And that's the sense of it, or the, that we're fighting with there in the jungle. I think it's important to keep in mind, and I certainly think this is what motivated Justice Scalia. I think it still motivates Justice Thomas and Alito, Justice Roberts, hard to say. Justice Kennedy's interesting along these lines too. I think they very much think we don't kill enough people. Capital justice has gotten in the way too much, right? That what justice means as defined by all you weak liberals is procedural justice, and procedural justice gets in the way of killing more people. That's what justice would involve, a lot more people being dead a lot quicker, not long after they do some terrible thing. And of course, yeah, we don't want innocent people there, of course, but here, I'll write 500 pages that tries to assert we've never executed an innocent person. So the fact that you even worry about that, you wussy liberals, that just shows you don't really care about justice. You care about bad people. And so from their philosophical view, at the most fundamental level, it's you really care about justice, it's substantive justice, and substantive justice means we should respond to all that data, look at all the people who didn't do the worst of the worst, who got the death penalty with, well, let's make sure all those other people get the death penalty, right? That's their vision of justice, and that's particularly their vision of why they're critical, and I think justifiably so, when we emphasize on the reform side, well, look how uneven it is. Yeah, it's uneven because you've done such a great job, this will be Alito's words, in this guerrilla warfare to keep more people alive, to keep more people off death row, to drive up the cost. You're impeding justice, or more accurately, what they would really be saying is too much justice as it's gotten defined by the Supreme Court and hardcore advocates for reforming the death penalty is really about too much imposition on our ability to kill the people we think ought to be killed because they've done terrible crimes. Practically speaking, this is the next layer of it. Practically speaking, they know that any change to their system, any alteration, any even enactment of a prospective abolition is going to lead to litigation saying you can't go backwards and let people off death row even after we've sent them there after trying to provide them with too much justice. We're afraid to switch from a 3-drug protocol to a 1-drug protocol because we'll have litigation over that. We want you to tell us, this is Alito and Glossip for sure, we're not going to let you, this is how they're going to do their version of too much justice, we're not going to let you get out of the death penalty until you tell us how we can do the death penalty. And if you can't tell us how we can kill you, we'll kill you any way we want to. And that's, again, not necessarily a sign that they don't really are interested in justice. It's just both theoretically and practically, their vision of justice is kill more people, and inevitably improving the death penalty will prevent them from killing more people. All right, a couple good examples of this then also being a fool's errand. One of my favorite stories about Mitt Romney, and I've got a lot of favorite stories about Mitt Romney. I really like the dog story where he left it on the car and all of that. But my personal favorite story of Mitt Romney, and it just shows what a both shrewd and stupid politician he was in the early 2000s when the Innocence Revolution was making the rounds. He thought it would be wise to try to bring the death penalty back to Massachusetts. And his pitch was creating a blue ribbon panel of experts to devise a death penalty system for his state that he deemed, this was the quote, as foolproof as humanly possible. And in fact, a terrific group of very smart people, including law professors, so I know they were pretty smart, and other really hardcore advocates came together, and foolproof at that moment in time, this is 2002, 2003, 2004, meant no chance of wrongful execution, no innocence problems. And they came up with this elaborate scheme with videotaping and all sorts of triple identification and DNA and you name it, everything we could possibly do to reduce, to make it as foolproof as humanly possible. And what happened? Both sides in Massachusetts roundly attacked the proposal. Why? Because the death penalty opponents said, well, there's still a chance it'll go wrong, right? Really, we don't want anybody to be executed. And the proponents of the death penalty said, oh, we'll never be able to get anybody on death row. That will be impossible to get anybody there. It's just not worth it, right? And so we had a blueprint, courtesy of Mitt Romney, a decade ago about how to do better. Same kind of story played out in Illinois, though their blueprint was after they had already had their entire death row commuted, so it wasn't a blueprint to bring back, it sort of was a blueprint to bring back the death penalty, and they decided the game wasn't worth the cost. They just repealed their death penalty. The last part of all of this story is, right, and this is the last part that gets to the public interest, the public doesn't care. the death penalty is of symbolic significance, and that's it. It doesn't affect their lives day to day. It isn't really important to them in any truly economic way, even though I agree completely with John's statements this morning. If we could help the public see that reinvesting the money that are being wasted on lawyers and advocates in this setting to other crime reduction tendencies, they probably would vote for that. But we're trying that in California, and that's not even working so well in California. The symbolic significance of saying we still at least have a chance to condemn to death the Boston bombers of the world still matters so much, both to the public, but especially to the politicians, right? And in fact, I think Sherrod said it this morning, it's always so easy and politically expedient to add another death qualification to the statute. That's where the action is politically, that's where the action is practically. So what does all of this mean? Well, it means that right-meaning people, like the Chief Justice of the Ohio Supreme Court, says, our system's not great, let's put a bunch of smart people together and try to fix it. But I'm taking abolition off the table, she tells us, as we convene this task force, and our mandate is to make sure the Ohio, this is the exact language, we were tasked with conducting a thorough review of capital punishment only to ensure that Ohio's death penalty is administered in the most fair and judicious manner possible. And the Chief Justice went out of her way to say, abolition's off the table, moratorium's off the table, I just want you guys to sit around, how can we fix this system? So we did what she asked us, and we sat around, and we came up with 56 modifications, and they're all great, right? So this is where we get to, this is number one. Custodial interrogations, as defined by Miranda versus Arizona, shall be recorded, and if not recorded, then the statements made during the interrogation should be presumed involuntary. That's great. That's a great recommendation. I voted for that recommendation. I know it's a great recommendation. It's not a death penalty recommendation. We don't do that in every case, right? And that's actually why I enjoyed working on this task force. This is where the rubber really hits the road for me in all of these settings. By virtue of being asked to try to fix the death penalty, we spent a lot of time on how to fix lots of aspects of our criminal justice system, and I'm cautiously hopeful, not optimistic, but cautiously hopeful the process did actually advance justice in Ohio. It didn't advance capital justice one whit, because every single one of these recommendations, that's a little bit of an overstatement, one or two were at least introduced in some way, but the key is, right, and here's the key that highlights how this was a kind of fool's errand. The capital prosecutors who were on the task force, who, by the way, tried not to show up until they got letters from the chief saying, you have to come and play along with us, decided they had to write a dissenting report as these recommendations came out, and they voted against a lot of them. That's why some of the votes are 13-5 or 18-2. Some of them they agreed with. Oh, by the way, the ones they agreed with also still haven't become law anytime soon, but still useful to know that they agreed with some of this. This was the start of their response to the task force or their minority report. Many of the recommendations would establish a series of procedural and legislative nightmares. In the view of capital prosecutors, quote, some of the recommendations would tie the death penalty system up in knots, creating procedural and litigative traffic jams that would potentially tie up particular cases in litigation even more than is already occurring, right? And I particularly liked their language. In several of the recommendations, the task force veered off course its narrow mandate and is making recommendations that are anti-death penalty. The work of the task force was strongly influenced by a pro-defense majority bent on an agenda of abolition, not fairness, right? That's obvious if we want to record custodial interrogations. Clearly, it's about death penalty abolition rather than fairness. No, it wasn't about that. It was about fairness. It was a very thoughtful effort by a lot of thoughtful people to really try their best. Okay, you want a better system. This is a script for making a better system. And of course, they didn't like that script, right? And because they didn't like that script, and because they're politically elected, and because the General Assembly, although a fairly conservative General Assembly, didn't like it either, they haven't moved forward with any of these recommendations. So what does all of that mean? What I think all of that means, and this is really where I'll end up, and hopefully we'll have some conversation, not only recognizing that nobody really wants a better death penalty system, leads you with two options, I think, right? One is continue to play these games of trying to pretend to make the system better and hope that has benefits for the rest of our justice system. And I think there's a little there, but maybe the bigger answer is everybody should invest all their time and energy in abolition, and that they should admit, in many respects, although we hear this in some of the comments earlier, there's no way to fix this other than abolition. I think that's how Lindsay ended her presentation, and I think there's a lot to that, but don't try to hide that would-be abolitionists. Put that front and center. Put that front and center or say there is a moral case. There's no such thing as capital justice, and even if there were, the political realities are we're not going to get there. And so abolition as a practical political matter is the only way to get as close to capital justice as possible in light of all the problems we're identifying, some of which do get made better in various ways over various times, but all of which I think are going to persist no matter how hard we try to mend rather than end the death penalty. And so I don't know if that's blood sport, but those are my thoughts.
Well, thank you. I know we're going to open this up and have a lot of conversation. Let me just throw my immediate impression.
Great.
Is that, your experience in Ohio, the ABA's experience in their 12 assessments of various states suggests to me that there's a false equivalence when you say that both sides fear too much justice. Because it strikes me that if you're in Texas or Ohio or North Carolina and you're looking at the justice system, you, in good faith, now coming from a moralist, someone who doesn't believe in the death penalty, in those states you can look at real-world changes in the operation of the death penalty system and make improvements. And the people who are advocating those changes are doing so in good faith. And, my question is, a question I have, and we can probably feed this in later, is it quite the same to smear those good folks with the people who bring up the crime scene photos, knowing what they know about how the system operates, and would shoot down the 56 recommendations in Ohio?
Right. So
are they really fearing justice, too much justice?
I will leave it out there, and I will, in my mind, start building the case for moral equivalence while Linda has a chance to
Very good.
give us an international perspective.
Right. Well, let's open this discussion up to the rest of the world. And Linda has given a lot of thought, Professor Malone has given a lot of thought to how the global reality should impact this conversation. Professor Malone.
Thank you. And very quickly, I just want to thank Matt and John and Aaron and all the other students for putting together such a terrific symposium. You've really done a great job. I'm going to put it front and center. Greg is a 40-year failed experiment, and it's been done with human lives. After Greg, the idea was that we needed to have these procedural protections, safeguards perfected in order to perpetuate the system of capital punishment. And what I try to argue in my article is that I think there's a confluence of several different things that are going on right now, several different developments that I'm hoping have put us finally at the point in time where it's a full frontal attack on the death penalty and an argument for abolishing the death penalty. And those movements that I think are leading in that direction, I'm going to focus on the international global perspective, but there's this shift from national consensus to reliability, to proportionality, to the purposes served of capital punishment. So we've gotten this shift away from what was sort of this almost moronic head counting. How many states do this without any real depth to that analysis and what was really going on in the scene? To going back to sort of a fundamental Eighth Amendment analysis, which I do think that Kennedy is espousing, which is it reliable? Is the punishment reliable? Is it proportionate? And is it serving any purposes in terms of criminal punishment? And then when you take all the empirical evidence that we have from several of the people today, which are showing that it is not reliable, that there's no proportionality, that we can't demonstrate that it's serving any kind of purpose except vengeance as opposed to retribution, and those are not the same thing. And then finally, what I argue for, and what got me in a sort of an outlier way into death penalty cases, was my involvement from an international human rights perspective. We are long, long, long overdue in recognizing the significance of international norms, practices, and consequences. And I call that global realism, stealing a little bit from Breyer's new book. And so just to give you a little bit of quick history in terms of how the international human rights community got involved with death penalty cases in the U.S. They were involved elsewhere, of course, but this has become one of the battlegrounds. After Gregg, they became involved in advocacy against the death penalty. And it was an uphill battle, very difficult battle. Anyone who has been an opponent of the death penalty or defended capital cases knows it's a career that is potentially fraught with tremendous disappointment, with horrific consequences when you do lose. And if you are arguing in death penalty cases on the basis of international law, you are doing an almost Sisyphean task of trying to, not only are you going back up again with your arguments and you're pushing that boulder of international law up the hill in human rights just to watch it roll all the way back again and have Scalia say it's totally irrelevant, and then you have to start that whole battle all over again. So I can truly say that for many years now, I have an extremely long and impressive record of losses in death penalty cases, to the point where at some point I thought maybe a defense counsel should run from me whenever I offered to be co-counsel or to be amicus in a brief. But I want to focus on Stanford and Roper in the juvenile context to show you that fundamental shift that we saw from 1989 into 2005. And keep in mind, again, sort of focusing on Kennedy's vote, because I'm trying to be optimistic and think that the time has come to put his feet to the fire. That he was appointed to the court in '88. And immediately he's confronted with the Penry case and Stanford versus Kentucky for execution of juveniles and what was then referred to as the mentally retarded. So he's barely on the bench, and these are the first two cases in the death penalty context that he sees, and he votes with the majority. It would be pretty striking if he did not, because at that point in time it was national consensus, and there was none. So I don't think you can look to that and say, oh, he's written those two, he joined those two opinions, any more than you can look at his joining Glossip in majority and figure out, well, then he's not going to vote in abolition of the death penalty. And in Stanford versus Kentucky, Scalia wrote in his opinion that international law, which he calls foreign law, is absolutely irrelevant to what constitutes cruel and unusual punishment under the Eighth Amendment, not even worth disregarding, just out of the picture altogether. Then we get Roper versus Simmons, and in Roper in 2005, Kennedy would write that opinion, presumably assigned by Stevens, who was also in the majority, and Kennedy would cite international sources and comparative law sources for what was going on in the rest of the world in terms of abolition of the death penalty and rejection of the death penalty. Now let's pause for a moment, for those of you who are not familiar with the international law human rights aspect, to talk about what the situation was in 2005 with respect to the death penalty. The easiest summary that I can give you is that the United Nations Convention on the Rights of the Child in 2005 had been ratified by 190 countries. Only 2 countries, really, had not ratified that convention: the United States and Somalia. Okay, and the UN Convention on the Rights of the Child prohibits execution of juveniles. So we start with that. Oh, and I will mention that Somalia has since ratified the UN Convention on the Rights of the Child in October of 2015. So that's another confluence that we might be able to utilize. And then I want to skip to the 2015 Montgomery versus Louisiana decision by Kennedy. And the sentence that's really stood out for me in that opinion, and in me being hopeful that perhaps the time has come with Kennedy as well, was his suggestion that the most impeccable fact-finding cannot legitimate a verdict where conduct is constitutionally immune from punishment. And I think you go back even to the much earlier Kennedy decisions, you see him exasperated to a large extent with all this, as one person has said, this alarming, unparalleled level of constitutional micromanagement of the death penalty, and with very little, I think, to show for it as a result. So the full implication of Kennedy's opinion was certainly not lost on Justice Scalia, not surprisingly. And he said, this whole exercise, this whole distortion of Miller, which said no life without parole for juveniles, and is just a devious way of eliminating life without parole for juvenile offenders. The court might have done that expressly, as we know the court can decree anything, but that would have been something of an embarrassment. After all, one of the justifications the court gave for decreeing an end to the death penalty for murders, no matter how many committed by juveniles, that's in Roper, was that life without parole was a severe enough punishment. How could the majority, and this is key, in an opinion, this opinion, Montgomery, written by the very author of Roper, meaning Kennedy, now say that punishment is also unconstitutional? The court expressly refused to say so in Miller. What this says to me, this is Justice Scalia saying to Justice Kennedy, you know, A2 Kennedy, have you gone over? And the reference to Kennedy being the author of Roper goes back to Justice Scalia's prediction in his dissent to Roper as to where that opinion might lead, and where that might lead unless necessarily kept in check by its author, which would be Kennedy. So in the Roper dissent, Scalia says, nor does the court suggest a stopping point for its reasoning. If juries cannot make appropriate determinations in cases involving murderers under 18, in what other kind of cases will the court find jurors deficient? We have already held that no jury may consider whether a mentally deficient defendant can receive the death penalty, irrespective of his crime. See Atkins. Why not take other mitigating factors, such as consideration of childhood abuse or poverty, some of the very mitigating factors we are supposed to take into consideration, that's in parentheses for me, away from juries as well? Surely jurors, quote, overpowered by the brutality or cold-blooded nature of a crime could not adequately weigh these mitigating factors either. Now, here's something I don't think you've heard from this symposium, and you almost will never hear from me. Scalia's right. Juries can't look away from the brutality and the cold-blooded nature of the crime sufficiently to weigh the mitigating factors. We've got years, decades of history that simply show that. We may simply be stuck with an aspect of human nature that we have to recognize and that no procedural fix can remedy. On the international aspect, a few months after Glossip versus Gross, Justice Breyer published his new book, The Court and the World, American Law and the New Global Realities. The premise of the book is this, that the Supreme Court can't avoid international law and international norms and practices in reaching its decisions. It's just become impossible in this global community. And it deserves emphasis to differentiate from an international law perspective what Breyer is saying here from the question of formal incorporation of international law into U.S. domestic law. Actual incorporation of international law as having the force of law itself is a hot-button topic. And it's a hot-button topic that came up, that was reignited, as it were, in Kennedy's opinion in Lawrence v. Texas, talking about homosexual rights and how everyone had the same rights to equality, based in large part on sort of a human rights norms type of argument. But what Breyer is saying is something, I think, much easier to digest and not quite as difficult to theorize. And it is just simply that what I've called global realism is that cases will increasingly have international aspects and consequences. And refusing to consider the experience of international law, norms, and other states in addressing domestic legal issues is actually an abdication of judicial responsibility. It's not just simply a nice choice to make, it's an abdication of judicial responsibility. And so what we see from the international human rights side in death penalty cases is that they are arguing both alternatives. They are arguing to some extent that international law norms actually incorporated into U.S. domestic law have a legal effect that must be recognized, but then also arguing, look, evolving standards of decency, how can that not possibly reflect the world situation and the world approach to these issues? And we simply can't disconnect and isolate any longer from those types of influences and considerations. Why not consider the best information that you have available? If you look at amicus briefs, if you look at empirical studies, why would you not look at years and years and years of law and practice in the rest of the world? What's the justification for that if you're not saying it's legally binding, but something to be considered and given some weight? And as Breyer notes in his dissent, most nations have abolished the death penalty. Of the 193 members of the United Nations, and that includes the Vatican and Liechtenstein and Monaco, 95 have formally eliminated, while 42 others have ceased using it in practice. In 2013, only 22 countries carried out an execution, and only 8 executed more than 10 people. The nations included in the 8 nations that regularly execute people are not the ones with which the United States typically prefers to be aligned. China, Iran, Iraq, Saudi Arabia, Somalia, Sudan, Yemen. In 2013, no execution took place in Europe or the Americas outside of the United States. Now, that's a pretty overwhelming global sense of evolving, not even evolving, I'd say evolved standards of decency in the global community. There are other international consequences. I mean, first, if you look at Glossip versus Gross, why did that decision came about? Because foreign suppliers refused to supply the medicines that had been used to commit executions in the United States. And that's why we had to deal with this question of whether this particular combination was or was not cruel and unusual punishment. But here are some other collateral consequences. The United States is a party to many treaties. One of those is the Vienna Convention on Consular Relations. That convention requires that parties that are states to it give notice to when a foreign individual is detained and arrested, that there be notice given to the consular office of that person's country that they have been detained and arrested. Now, if you're an American citizen, you certainly want that to happen if that happens to you in another country. Well, it was not complied with for years under the Vienna Convention. And as a result, in 2004, local and state authorities failed to carry out this obligation by not informing 51 Mexican nationals of this right. Well, that led to a case called Vienna that went all the way to the International Court of Justice. And in Vienna, the International Court of Justice says the U.S. is a party to this treaty. It says give consular notice. You didn't give consular notice. You violated the treaty. You know, that almost seems like a duh moment, right? Well, Texas said, that's too bad. We're not going to do anything about it. We're not going to provide any remedy. And President Bush tried to intervene and said to Texas, why don't you do something about this? look at this decision of the International Court of Justice. Think about giving some effect to this. No result. Case comes back up with one particular individual that was in the Vienna case, and it leads to the Medellin versus Texas case. And in that case, the majority of the Supreme Court concluded that the convention was not self-enforcing, that it had to be implemented by domestic law in order to be legally binding. And without getting into all the ambiguities about what's self-executing or not self-executing in a treaty, when a treaty says, thou shalt give notice, that sounds pretty self-executing to my ears. But the majority said no. Justice Breyer was in the dissent and said that the treaty was self-executing and enforceable, and the judgment of the ICJ was as well against Texas. Another landmark case that European countries know all about, even though many Americans don't, and that was the Soaring Case. In Soaring, we had a University of Virginia student and his girlfriend. He was from Germany. I think she was Canadian. And together, or him, they killed her parents. And they fled the country. And they were arrested in the United Kingdom, and the United States sought extradition. We have had tremendous extradition problems because of the death penalty in the United States. So when the United States sought extradition of Soaring from the United Kingdom to go back to the United States and be tried for murder in Virginia, the U.S. gave assurances to the United Kingdom that the death penalty would not be imposed. And the United Kingdom said, you can't do that, you're not Virginia. That's not enough of an assurance for us. Meanwhile, Soaring files in the European Court of Human Rights under Article 3, which prohibits torture or inhuman or degrading treatment. And he argued first that the death penalty was that, and that given the likelihood that he would get the death penalty, that he could not be extradited back to the United States without the United Kingdom violating its treaty obligation under Article 3. He also argued that the mere circumstances of being on death row, what the court would describe as the death row phenomena, all of the things that we've been talking about today, he also argued that that in and of itself violated Article 3. The European Court of Human Rights looked first to the assurances that he wouldn't get the death penalty by the United States and said, that's no assurance whatsoever. If Virginia wants to do it, there's nothing you can do, United States. So that's not enough of assurance, and there's a likelihood that he might get the death penalty. The court did not find that the death penalty itself would have violated Article 3, because at the time there were some limited exceptions to it in the European Convention. No longer the case, but at that point in time, the court rather modestly said, we're not going to say that it violates Article 3. But the court did find that the circumstances surrounding being on death row and everything that came with it, the solitary confinement, the delay, everything that we've talked about so far today, that all of that together constitute either torture or inhuman or degrading treatment at the very least. And as a result, the United Kingdom could not extradite this individual back to the United States. Now, as long as the death penalty is on the books, we have that extradition problem, because most of the world does not accept the death penalty. Any of those that have a treaty obligation, and that includes all of Western Europe, among others, that has a treaty obligation not to extradite in those circumstances, cannot extradite back to the United States. So in a way, we are also subverting our own system of justice and precluding some actions we might wish to take. Finally, on a sort of a different bender, in yesterday's New York Times, Linda Greenhouse wrote an article that I've mentioned to a couple of you called Resetting the Supreme Court, talking about the current vacancy and filling Scalia's vacancy. And she's a very diplomatic and very knowledgeable journalist on the Supreme Court. I mean, several of us know her. And this was a pretty pointed criticism, which said that this is a point in time where the court needs to reset itself, that it has lost the respect of the American people, that its disapproval rating is now higher than its approval rating, and that is a sharp departure from historical trends, that it has become a partisan body. And she cites an article soon to be published by my colleague Neil Devins and one of your political science colleagues, Larry Baum, showing that the partisan politics in Congress and in the country generally have invaded the court. And she pretty bluntly blames Justice Scalia for doing much of that and making the court so rancorous and partisan, and calls upon the court to reevaluate itself and start thinking in sort of these partisan ways, part of which the article she refers to attributes to the fact that more and more elites, whether Republican elites or Democratic elites or liberal elites or conservative elites, however you want to characterize them, are just not listening to other points of view. And she uses the article to show that the fact that Thomas and Scalia have only had 2.3% of their clerks come from circuit courts of Democratic appointees, as showing that they've abandoned even the pretense of trying to do what Scalia for a long time prided himself on, which was always to have one liberal clerk, at least, among his clerks. And last week, if I can switch my hat for a moment to international environmental, last week the Supreme Court did something incredibly unusual by a 5-4 vote. It stayed the Clean Power Plan of President Obama's climate change initiative. It did so before a lower court had even looked at the case. So it stayed a regulation from implementation before it's even been examined by what will be the first court to look at it, the D.C. Circuit Court. Now, that's not only unprecedented, I think that's legally unprincipled. And it's very, very hard to find a legitimate explanation for that kind of action. So where that leaves me, that sounds very negative, but where that leaves me is I think that this is an opportunity for the court to reinvent itself a little bit, that I think that global realism really does have a place and just simply cannot be ignored, and that maybe human realism also has to come into play, if I can use that term. So I'll just conclude by quoting from Justice Breyer from a speech he did abroad a few years ago. "I am inevitably the lawyer that I am. That means in respect to views about the nature of the Constitution or of law, their relation to the people of the United States, and the way in which law affects people, I cannot escape my own general views. Law is not computer science, and those views matter. That is why it is a good thing in a country as diverse as ours, with well over 300 million people, that different judges have different general jurisprudential views. I should add that judges serve long term, but over time, different presidents will appoint different judges with different highly general jurisprudential views. The court can change its nature very slowly over time, and in a few cases, it can reflect, in a highly abstract general sense, the nature of the country." So I think that's a call for Furman 2. That's long overdue. Thank you.
I thought that the greenhouse column was really provocative. And I haven't heard from you, Linda, whether or not you think there are prospects that this court would be looking take a different look at the global thought and would be impacted by it. And if you're willing to hazard a guess about that, I'd be curious. My own pet peeve I've got with Rob is whether or not the Chief Justice Roberts, is different from Scalia, Alito, and Thomas in that regard. And
well, I have to say I focused on Kennedy, and I was writing the last sentence of my conclusion when I heard that Scalia had died, so that threw a little kink in my plans for my analysis. But I think Kennedy is certainly in the camp of saying we cannot ignore the global realities. So I think that there's clearly the five that I would say follow that. Roberts, I'm just not quite as sure about that. I would like to think so, but I do think Kennedy's at a turning point, and although I think there are still areas where he's going to be adamant in terms of state rights and continue to be sort of very sensitive to state authority and not infringing on state authority, I think there's signals that have been given that this is one place where he's not going to be as deferential to those kinds of questions. It also, I mean, it may be obvious to some people, but I thought it was also extremely important that Ginsburg joined in Breyer's dissent, because we haven't really talked about that, and I would just say that she's an incrementalist. She doesn't believe in going in with guns blaring. She believes in taking your time and making the evolution happen. In fact, last summer at the DC Summer Institute for Duke, she was speaking and she talked about how much admiration she had for Justice Marshall and how he just chipped away at every little bit of racial discrimination until it got to the point where he said, see, it just totally unravels. You have to have this rule. And I think that she was willing to sign on, indicated that she thinks the time has come, that there's been enough incrementalism where we just have to now, at this point, say, this didn't work.
Yeah. Doug, I wonder if you had a quick response to my question about the false equivalence.
Sure.
And then open it up to the audience for...
And I'm not sure I want to take on that it isn't falsely equivalent. I'd more articulate it in terms of what obligation do you think advocates have in any component of the setting to not only be fully candid but quite loud about their desired end state, right? So to me, you could say, oh, it's a false equivalent because the folks who are working on the ground not to eliminate the death penalty when they're litigating individual cases or making different kinds of advocacy are just trying to improve what we've got here, but they're not out there screaming that what I think most of them, at least the ones I know who are motivated by, and I want this to be chipping away until we get rid of the death penalty altogether. And that part of it is they don't have to say that, but part of it also is if they say that, then their arguments for, I just want an improvement here, look differently, whether legitimately or not, right? This became a big point of debate, particularly in the context of the first round of the lethal injection litigation in Bays, right? And I think that was actually a big part of what led not only Justice Alito to be so aggressive, but in some sense his ability to get Justice Kennedy to go along with him here, which is, look, we actually in Bays articulated a standard that was, we thought, moderate enough, but wouldn't allow the death penalty opponents to keep trying to kill the death penalty with 1,000 cuts. And gosh darn it, they're still killing it with 1,000 cuts, and so therefore we've got to now put the burden on them to make the standard be you only get to win if you can prove up another way that we can kill your clients. And of course, understandably, defenders of those on death row don't want to propose nitrogen or any other method that would be better to kill their clients, but that's where I think Glossip itself grows. I mean, a lot of people were stunned by Alito's even question along those lines that the doctrine could run that way, but I think it was, I think particularly Alito and Roberts, who thought they were being moderate in Bays, felt like they were set up. Now, whether it's appropriate they feel that way, I don't know, but that's their own sense of, you guys are the immoral ones. Now, I don't think that's right. That's their perception. And then to put it on the other side, and this is, I guess, the really, really interesting candor case, right? So when Bill Otis or Kent Schneidinger or the folks who blog at Crime and Consequences, who are kind of my litmus test for the most pro-death penalty, eager to have more people killed, and isn't it tragic that we don't execute more people more quickly, put up pictures of the victims of the South Carolina shooting or the Boston bombing, I think they would readily admit, we want more murderers killed. And I think they would be inclined to say, although this one's a little bit dicier, and we want a world where if you truly are intellectually disabled, if you truly are subject to terrible defense representation, you won't get killed. And certainly if you're truly innocent, we don't want you killed, right? So they would readily admit they want more killing, but they would also say, I think, and we think a properly run system would have a lot more killing of the right bad people, right? And that's why, of course, they're inclined to point to Dylan Roof or Sonarev, because there doesn't seem to be any question about guilt. They're going to get awfully good representation. The racial dynamic is interesting there, but remains to be seen. And this is where the delay is the most classic example of this, they'll happily say, we'll deal with your death row phenomenon. Let's make sure they're executed within 10 years. I think that's actually part of Ken Schneidinger's proposal for reforming California's death penalty system, is to have a time limit on how long you could drag out appeals. And so, and the last piece of this would be, I think they believe, I'm not sure I share this, but that it's actually more moral to show those pictures because that's part of the reality. That's part of the reality that the victims are facing. That's part of the reality that society experiences. That's part of the reality that drives people's fear here, right? And that fear, though maybe not rational, though based on emotion, is as honest, arguably more honest than looking at a whole page of statistics that make your eyes glaze over, right? And so, I mean, and maybe this is at the core of Linda's point, which is the fact that those pictures move us more than those statistics may be a human phenomenon that, for me, is a human phenomenon that keeps the death penalty in place. And to the extent we say, Supreme Court, take us out of that human reality, we can't trust ourselves as political institutions and as vengeful animals to run a system that includes state killing. I think that's a perfectly appropriate thing to say, but it's quite a statement of human failings that worries me, not just with respect to the operation of a capital punishment system, but a lot of other things the government does, right? And that's what's sort of funny, is I'm a libertarian when all is said and done, and I actually think our failings here is proof that even when we try and throw all sorts of money at it and do our best, when there are real huge challenges to doing something well, government doesn't do it very well.
Rob?
Two really quick comments and a question. The first is, you're a brave man for going inside the psychology of either Bill Otis or
Hey,
Kent. So
know thy enemy, right?
Congratulations on that. The second thing is, note that your point about Justice Kennedy and others, even if they might be willing to sort of get rid of most of the death penalty, but not for things like terrorism. Obviously Kennedy, like in Kennedy versus Louisiana, they say no non-homicide offense, footnote, except of course like airplane piracy. So, there's some support for that theory. And I think there's a petition in front of the court now in Tucker versus Louisiana. We talked about that case today. And the footnote is, of course, we're talking about for homicide crimes against an individual, not terrorism. So that seems to be a carve that, and so the question I had is about the Boston bombing case. I guess when you talk about what do the people actually want, you say we're these vengeful animals, and so there is this risk. Kennedy says we risk when we punish, retribution's our goal. We risk this descent into brutality, right? And so what the government's obligation is to be restrained, and so there's this question of when across the entire country you have 49 or 50 and they're concentrated places, is this a measure of retributive excess in these couple of places or systemic failings, or is that what's going on rather than it's regular? And so that brings me back to Boston, because you have this community where the state of Massachusetts doesn't have the death penalty. And then in the county where the guy's being prosecuted, the vast majority of people say, even for terrorism, we don't want the death penalty for this guy. But you have a system now, which I think is very different than the jury review function at the time of the founding, that says if you can't impose a death sentence, you can't serve. And so now you've eliminated all those people. And I wonder, it seems to me like that's a structural, if you're saying we're making judgments about what people actually want, that's a major structural defect.
Right, and so I think very interesting the idea that, and maybe this would be the good, hard question, right? What would be the one existing fix, right, that you would like, and I assume one of your fix would be no death qualification of juries, but I assume the reason you'd like that fix is because then I think I'd always be able to get a jury that would have a holdout, right? And that's okay, but then that gets to an issue of, does unanimity, I mean, this is what Florida's dealing with right now, right? And this is, in fact, a huge thing that Ken Schneidinger is busy complaining about, right? He doesn't like the fact, he thinks the reason we don't have enough death sentences is a unanimous jury requirement for the decision to grant death creates a single juror veto, right? And he also thinks that the abolitionist community has been very good at encouraging people to sneak their way past death qualifications, and that's why we didn't get the death penalty for, what's her name, in Arizona, Jodi Arias. That's why we didn't get the death penalty for James Holmes. That's why we didn't get in all these other cases where I think those people should be subject to a death sentence, right? And again, that's not to say you're wrong that the way we've constructed our jury system is tilted towards death sentences. It is to say that they think, no, actually, the way we've structured our jury system is radically tilted away from death sentences. Although the really interesting, and this gets into some nuts and bolts stories, which again is itself a fascinating, for me, version of the more you know, the less you're willing to vote for death, right? So Colorado goes from a jury system to a judge system, hoping that will lead to more death sentences. And then it turns out when the judges sit around and think about this, they never vote for death, and so they go back to a jury system, hoping we'll get more death sentences, and then they don't win in James Holmes' case as well, right? Now, there's lots of other parts of that story, but I think that's the pushback. The pushback is, even with death qualification, you have the right arguments for this isn't the worst of the worst, and the guys get off, right? I mean, this is really what Scalia's always been saying. It's a defense of juries at the end of the day, right? And that's why, here's where I come back to my other part of sentencing. I'd love to have jury sentencing in all those other cases, and you can prison qualify everybody, right? I'll leave everybody off the jury who thinks we should never use prison, right? And so again, that, as foolish as that sounds, that's, the abolitionist community doesn't realize how out of whack with everything else that we do in our criminal justice system, what they say should be the norms are for a fair system. And I'm not saying they're wrong to say that's what a fair system would be, but that becomes a standard of fairness, a standard of too much justice that so rankles people who are, this is the other part of the story, right, who are involved in the rest of the system, right? That's where these prosecutors like Dale Cox, he's like, you know, I roll over those buy and bust guys like that, right? Why does the murderer I gotta work so damn hard, right? And so that's where, again, I think a part of what's in the mindset of the Bill Otises of the world is, I get to squash felons like bugs, and then the ones who are really bad felons, like, they're really big bugs, and it's a lot more work, and that's no fun, right? And so, good, bad, or indifferent, that's the culture, not just in which our death penalty situates itself, but the people who are so motivated to be willingly to say out loud, we should kill more people in the jungle. That's how they see it. That's their universe. And the saddest part for me, right, so this is where it all comes full circle, is, and they're very good at convincing the average voter that they're the right people to be engaging with justice in that jungle, rather than there being as much of an effort. I mean, this is almost an Obama point, right? We got to go in the community and convince people rather than just go to the courts.
Frank?
This issue about local variation, one of the justifications for it seems to me always to have been something about local public opinion. And local public opinion can be measured, I guess, in at least 3 different ways, and I just wanted to get some reactions to this idea. One is, whom do they elect as the district attorney? So that's a reflection somehow. The second is who shows up on juries, which of course is filtered by the death qualification. And the third would be some measure of public opinion. And when we measure public opinion across states, it's hard because it's measured by surveys, and we don't always have enough observations within each state, and certainly not by county. It's very difficult. But the Houston Chronicle did a survey in about 2003 where they had a big survey of Houston residents, and then also state of Texas residents, and also a national survey. And the Houston people were statistically indistinguishable from the whole United States. Same level of support for the death penalty as across the country, and much significantly less supportive than the rest of Texas. So it does suggest, and they're the epicenter, of course, of the the buckle of the death belt. So I just wonder, what do you think is the constitutional import of these kinds of public opinion indicators? And how much local variation is constitutionally acceptable? And how much would be somehow above a threshold of unacceptability?
My reflection is when I read Glossip and Breyer, he's valuing the change, the shift in public opinion, even at the use of the Gallup poll, which is pretty limited in the inquiry. So I think whether you look at something like that from Houston would seem to be powerful. I think his whole county approach is trying to get at that local opinion. I was struck with Donahue's graph on Connecticut that the clearance rate for homicides was as low in Connecticut as it is in what I thought was like Baltimore, in Maryland, and other states which really undernourished their law enforcement system. That when I hear this notion that the Schneidegers of the world think we just need to kill more people, and I listen to our friends like Mark Maurer, who says we've got all of these people serving LWOP, and I any statistic I throw would undercut it, but there are tens or hundreds of thousands of people with LWOP sentences. Yeah, our system has gotten so excessive in punishments that there really is a question as to whether or not folks like the Schneidegers, folks like elected DAs, are distorting the democratic process by bringing these crime scene photos to the legislative process. So I recoil when I hear the notion that the crime scene photos are as legitimate as any other piece of argument when the person providing that piece of evidence knows the full facts that you've described, that we've described today, and are throwing that in for the explicit purpose of generating an irrational response, and a response out of anger and vengeance. And should that enjoy the same moral acceptance?
So the question is, would statistics about increasing
Right.
homicide rates be in the same ballpark as a picture, right?
Yeah.
So is that also kind of inappropriate plays to fear? The classic one right now, this is going on in the other sentencing reform arena, is in my own Columbus, Ohio. There was a guy who was released early, though not really early, from a long crack cocaine federal sentence because of a variety of amendments that were made retroactive to the federal sentencing guidelines. And during the time that he would still be imprisoned if he was serving his right sentence, which of course was radically too long and, because of racial bias and the setting of crack sentences, he came home and stabbed to death his ex-girlfriend and her 2 children. And so Wendell Callahan is the name of the offender. And every conversation I have at all about sentencing reform right now is, there's 3 dead people because of you advocating for sentencing reform. What's the number of dead people you're willing to tolerate for sentencing reform, right? And he's not showing, well, he did show pictures of the 3 dead people as well, but, those are facts. Now, they're marshaling the facts to drive up fear. And really, the problem is, and the problem that's persistent and is why we're struggling so much to get out of our punitive way, is punitiveness is a one-way ratchet. Crime is high, we need to get tougher. Crime goes down, see, toughness is working, let's stick with it, and hey, maybe we'll get crime to go down even more if we go even tougher. And in fact, I will say, and I think this is an interesting moment at where the death penalty abolitionist community is winning. The folks who want more toughness have not been pointing to the significant reduction in death sentences and executions as a way to account for the increase in homicides that's getting all this attention in big cities, right? I've found it very interesting that even the Ken Schneidingers and the Bill Otises and the Michael Rutherfords of the world are saying, see, this is because of sentencing reform, not because of the guerrillas going after the death penalty. And I think that actually is a pretty significant reality that they've given up wanting to really buy into. This was discussed a little bit earlier. Nobody's trying to run new deterrent studies. Now, maybe they're busy in their little labs right now running new regression, showing, see, look what, and for whatever it's worth, the people who don't like marijuana reform are running those regressions for Denver and Seattle as well. So everybody can run their regression to prove what they want to prove in some settings. But I think, the reality of crime, and I think Frank mentioned it earlier, there are a lot of murders out there. It's just the simple reality, many more than we should have. I like to emphasize there's also far too many people who die from drunk drivers, and that still eclipses the murders. And so, which layer of that emotion is more real and more fair and more morally equivalent? I struggle with that all the time.
Sure.
All right, so I want to apologize in advance. This question is not as crisp as I would like it to be, but just work with me. So this is for you, Doug, but I think it might have some implications, some relevance, and I'd be interested to hear Linda's thoughts as well. So listening to your talk, I was trying to kind of bring together several themes that you mentioned, and the way I've kind of categorized them, I could think of again, kind of a state-by-state approach to attacking the death penalty, the McCleskey case and constitutional interpretation, and we could think about the kind of pitfalls of incremental fixes. All right, and so, thinking about McCleskey, and it's rightly so, many people, they talk about the for unusual punishment, the arbitrariness claim. From the way I read it, the court basically said the results weren't stark enough to support, the risk wasn't as high, but not that no statistics whatsoever would could support arbitrariness claim. Again, that's on the Eighth Amendment challenge, right? The inability of statistics to prove intentional discrimination. That was a due process challenge on the rights, right? So it's still two things going on there. But it also had me thinking about, I think, what John said with Santiago, and also I'm thinking of New Jersey. I think often was the case where the court saying, listen, if we had that McCleskey data in our states that was a start, that would be compelling. And it wasn't, you have to read the opinions and some is a little bit, probably on a due process claim and definitely on Eighth Amendment claim, so it could be as compelling there. And so when thinking about that and thinking about the kind of trend and abolition that we've seen at the state level, saying going back to your state-by-state approach, we could think of kind of the legislature, and we can think about ballot initiatives, but also thinking about constitutional interpretation. Again, I just referenced to again with Santiago and Laughlin. And so I'm wondering, do you believe as, advantage of practice as a state-by-state approach, but kind of believe the constitutional interpretation at the state level could somehow filter up and influence interpretation at the at the federal level, and then again that kind of brought me thinking of international law and norms in general, and that's why I thought about Linda as well. So again, not a crisp question, but there's some meat in there, I think.
No, I think absolutely, and so I'll start with I think state constitutional development has lots of potential action there, right? And one of the many things I like, may biased a little bit from being in Ohio, but I think it's part of a broader kind of vision I have about state constitutional work being more potentially in harmony with democratic commitments than Supreme Court work here, right? Because they're more regularly elected or appointed. And, again, that was historically part of the problem is Rosebird gets thrown off the California Supreme Court because of this stuff. But I think we've lowered the salience of death penalty discourse so much so that it's not only possible, but arguably likely. Now, it would involve restructuring some aspects of when and how we elect judges, but that there's work to be done there, and I think if state courts do that work and don't get voted out because of it, that would level up in a variety of ways, although I think this is itself part of what I'm working on, the sentencing reform arena, that I think is also true in the death penalty arena, is people, particularly older politicians of all sorts, older judges of all sorts, they remember the first time they were elected, not the most recent time they were elected, right? So a huge problem right now with all justice reform is most of the people in power in a variety of ways, Hillary Clinton included here, remembers the 90s and 80s when if you even hinted that you weren't tough on crime, you were shown the door. And they still think that's the dominant theme. And Obama himself was subject to this where he said, I put Sotomayor up because she was a prosecutor and therefore they couldn't go after her. And it's like, they could go after her anyway, and that's so much he's a prosecutor. It's not always good to have prosecutors on the Supreme Court, although she's been fine on these frontiers. And so I think there's significant there, and I actually wish that was another layer of kind of state-by-state investment. And it actually sounds kind of depressingly that the prosecutors in Connecticut are so keen to undo the outcome there that they're trying to do it the other way in Connecticut, as I understand it. But I'm especially curious why Jerry Brown hasn't figured out how to put on the California Supreme Court enough folks now who would get rid of their death penalty as a matter of state constitutional law. And I don't know if they would be, I mean, I guess this would be the good question to you, and I'll fish that. Should the California Supreme Court justices, given that, as I understand it, California is the 7th largest economy in the world, be open to hearing the international story, right? It's not just the death penalty in our nation affects the world. The death penalty in California affects the world. Is that where we should be pitching this, at least until one of them gets on the U.S. Supreme Court?
Yeah, I've been involved in a case that pitched it in Virginia, and I can't say that it's very fruitful. I think you throw anything in there that's a possibility, but I really see it being more of sort of a blanket argument that's going to have to reach to a pretty sophisticated level. I don't see any reason why not to use it in state court arguments and so on, but I don't think that it's going to be as powerful in that context as it is in some kind of overall national challenge.
So you talked about like the Supreme Court like possibly using international norms as like, you know, at least persuasive authority in deciding these cases. But let's say like that happens, like Breyer gets his day in court and he gets to like do that. I guess like this is just like my lack of knowledge, but is there actually an international, like is it customary international law or is it an international norm against the death penalty? I know there's probably not something like for the death penalty, obviously, considering what you've talked about with all the countries that have abolished it or put a moratorium on it. But would you go to say that there is, in fact, like CAL now against the death penalty?
There is. Quite simply, there is customary international law that is against the death penalty, given the numbers. It's prevalent enough. The states are doing it because they think it's required by international law. So that gets us into that separate question of not just looking to other countries for evolving standards of decency, but to what extent is customary international law actually enforceable in our own federal courts? And although it's rather chic from an international law academic perspective to argue that it's not, I'm very originalist on this point of view, which is that the framers did intend for international, customary international law to be part of our law, that the Alien Tort Statute of 1789 makes that absolutely clear, and that in that area, it's really been a disappointment to see how we have not recognized. Once we left the rubric of being the country that wanted the protection of international law for ourselves to the country that we are today, we tended to lose sight of how much we established this country on the basis of recognition of international standards of decency.
Pretty fascinating to have an international consensus across Judeo-Christian traditions, Islamic traditions, Asian traditions, common law traditions, civil law traditions. So this is going to be a loaded question, and I apologize for it, but how can we account for our stubbornness here? Is it simply this notion of American exceptionalism, which I think you may have just alluded to? Is it this fierce tribalism that you have in our very unique Republican form? What accounts for our resistance?
I do think it is American isolationism and exceptionalism to a large extent, no question about it. I also think that on the court, this sort of originalist approach to our Constitution really shut off a lot of very valuable sources of discourse and reference that we should have utilized, if not in terms of binding law, but in terms of sort of guidance. Why shouldn't we look, as we're dealing with terrorism, for example, why shouldn't we look at other states that have had extensive experience dealing with terrorism in terms of what the procedures should be or how it should be addressed or whatever? As the court has gotten more receptive to looking at something beyond simply the legal record before it, whatever else that might be, and a lot of the evidence that we talked about today, why this deserves any less consideration. I really do think it is judicial abdication. I don't think it's just simply a question of, well, you can look at it or you cannot. It's that it's a part of your judicial responsibility to assess these things and not shut yourself off from something that might be very informative to your decision.
Frank?
Federalism in there to answer this question, because at least for the modern death penalty, so much of it was a response to the Supreme Court from localities. And among death countries, the United States and China are the only two that decentralize the application of the death penalty away from the national government. So it's a big issue.
In the back, and then.
As kind of a follow-up to this line of conversation, how would you recommend limiting the scope of using international sources to just the Eighth Amendment, or would you? And as kind of a second question, towards the end of your talk, you were kind of saying that the court needs to reset and stop being kind of politicized. And maybe I'm misinterpreting that, but if a lot of the value of international sources is kind of saying this is good policy, how does that actually help the court from seeing less like a political branch and more like a judicial branch?
Well, I think because of the standard itself, and I do think the Eighth Amendment does lend itself to that perhaps in many ways that other constitutional provisions do not. And I think it's very valuable that the court seems to be shifting from, as I said, the national consensus. Just count how many states blindly do have the death penalty and how many don't in that context, to this question of proportionality, which we find a great deal in comparative law and international law, and the idea of reliability. Those are all very familiar notions in comparative criminal law systems. And so I think that in terms of the evolving standards of decency, I mean, the Eighth Amendment really is, as a society, what do we consider as the decent thing to do in terms of punishment? And in that context, I think human rights has a very valuable role to evaluate that, and having struggled with that in the context of many difficult situations, many horrendous crimes. Some of the most horrific crimes imaginable are committed at the international level.
Again, in the back.
So I'm curious, in Justice Kennedy's Obergefell opinion, that phrase, evolving standards of decency, appears, and he seems to be suggesting that our laws need to conform to those evolving standards of decency. Do you see that as any chance of foreshadowing a change in his jurisprudence on the death penalty?
I hope so.
I've actually pointed an awful lot, and I think you talk about state by state, right? Nebraska is going to have a chance to bring back its death penalty in this election cycle, and California is going to have, it seems, a choice both to either end or mend its death penalty in this election cycle. And I would think if both of those votes go against the death penalty, Kennedy, especially because he's drawn to California, will be significantly influenced. If they go for the death penalty, I also think he'll be significantly influenced. And again, I think that's partially because it's not just that Kennedy believes in states' rights. I think across, I think we all live in a modern John Hart Ely moment. And by that I mean we all ultimately think the role of the court is to stay out of the way of democracy except when you can't trust it. And I think one can readily have, and I think a lot of what we see here, and I think Frank's research kind of reinforces this idea that democracy may be dysfunctioning a unique way in this particular setting in the operation of capital punishment, but to call it dysfunctioning requires you in some sense to say democracy can't function well with the death penalty. And again, this is what I think is really interesting, is the extent to which the Supreme Court, this is the Steiker's point, have helped ensure that the kinds of misbegotten cases here, right, the kinds of settings in which we see these disparities are still disparities between this not so bad murder and this really bad murder, not the difference between this black guy accused of raping a white woman and this white guy who killed 45 people, right? That the extremities of it. And I think this was actually what the Baldus study confirmed, that's often conveniently overlooked, that, yeah, race makes a big difference for the kind of in-between cases, but really, really, mitigated murders, race didn't matter that much, and really, really extreme murders, race didn't matter that much. And so, yes, that's where the action is those in-between cases, but for me, it's always reinforced that egregiousness scale that we're talking about here. Yeah, we don't do a great job on it, but we're doing certainly better than they did 100 years ago, 1,000 years ago, when they sometimes didn't even seem to care if the person was guilty, right? I mean, that's the story of the Scottsboro boys. It's, who cares if they're guilty? We just need to kill somebody. And the hardcore utilitarians say, hey, if you stop a mob, that's good enough for us, right? And so we've gone a long way. And I do think Kennedy won't wait. Let's put it this way. And I'm not sure it's just Kennedy. I think Roberts is gettable here too, right? If it's about, and this is why I think the state counting still matters, if it's ultimately about stopping those 5 or 6 crazy states that haven't gotten in order, right? I think Hall is a little bit of this, right? This is, making sure the states take seriously the limit on intellectual disability, and a couple states are still trying to evade that with their own little, we'll smack those down and with some pretty strong language. But when it's making the blanket call on whether or not you should have the death penalty, I think Kennedy still kind of trusts the people. I mean, I guess the perfect would be to, have it pass and then it be proven that there were all sorts of actual lies done in the advocacy, right? Everybody's seen the ad that Marco Rubio is so upset of with Ted Cruz put together, where Rubio is shaking hands with Obama with like these big grins and smiles, right? If they put, I'm trying to imagine, the sort of the version of the terrible ad that truly would be a lie, but my guess is they're going to show, pictures of the Boston bombing, right? And say, are you saying this person, what if we have another one of these, or the San Bernardino shooters, right? I mean, we're going to see that already. There's already a bill being proposed to order Apple to crack into their iPhones because in the face of an extreme crime, what our other values are diminish, and call that emotion, call that unfair. I call it human, and there can be something said for we can't trust humans here, but I don't want to, I kind of think I channel Kennedy in thinking he doesn't want to get there unless he has to.
Don?
Just toss out something from China. I led a group of lawyers to China, and we were meeting with the Supreme Court justice there, and obviously the death penalty was a topic, and they had devolved their death penalty down to a more regional and local level, and the numbers shot way up. And he said, but we've dealt with that. And I asked how they dealt with it. And he said, well, it's very simple. Now one of us, there are obviously way more members of the Supreme Court than ours. Now one of us has to meet with every person before they're executed. And the numbers came way down. So maybe that's a way to address our Supreme Court. Offer them the Chinese model and see how they feel about that.
Rob, you may be the last question.
I think Doug has made the best case possible for a more robust version of the Justice Kennedy Eighth Amendment, because that extends far beyond the capital context. Because when we're talking about, like, we're not these rational calculators, and we have no, like, so what you would say is we have this murder, but the question isn't like, is this person going to kill? It's like relative to the baseline level of violence. Like, is there a reason to believe this is, much more likely? But we don't do that. We have these moral panics. So, like, we have 3 strike laws after Polly Klaas is killed. That's all over the place. We have, like, crack murders and crack babies, and then we have, like, juvenile super predators, and JOWOP goes up. And so it's always the story. It's this hysteria, a lot of it's racial hysteria, and then it backs off. And that's why I think it's so important for the court to come in, is because now it's 25 years later and we're like, oh shit, like even DeLulio, is like, I was wrong about super predators. Crack murders, maybe not that big of a thing. But like the legislatures aren't going out because you always have the guy who could possibly go out and do something, so there's no incentive. And so then when you look and say, well, what are jurors doing in actual cases on the ground? And we realize that the vast majority of times they're not applying, whether it's juvenile life without parole, nonviolent LWOP, the death penalty. To me, like, that's what Justice Kennedy is so powerful. He's saying, like, sometimes, as Lindsay's mentor said, sometimes it's the court that's actually the more democratic branch.
Well, let's give a round of thanks to Professor Berman, Professor Malone.
Yes, good job. It's so interesting. The international stuff is just so great. I really loved your phrase, right, which I'm going to use all the time, right? The cases have increased.
Well, I'm Jonathan Robe, and the editor and chief of the Duke Journal of Constitutional Law and Public Policy. And I think we can all agree that this has been a most illuminating and engaging discussion that we've had today, and I would just like to thank again all of our panelists and participants for that. Who knows, in a couple of years, we'll be reading a Supreme Court opinion with all of these distinguished names cited, appropriately treated and cited in that opinion. As we leave, I would like to reiterate thanks to a number of people. First off, I'd like to thank our sponsors, Quarles and Brady, and the Eighth Amendment Project for helping us put this on. I'd also like to thank our faculty advisors, Professors Daryl Miller and Ernest Young, for their support, and I would especially like to thank, again, our outgoing faculty advisor, Joseph Blocher, who has gone truly above and beyond the call of duty. Not only was he helping us in the last 2 weeks while he was caring for a newborn, but as I was thinking today, the seed for this symposium was actually sown about a year ago when, at about 8 p.m., when he was trying to get out of his office and head to home, we cornered him in the hallway, to figure out who were the best and brightest minds to bring to help us put this on, and I think it's been a true success. So I would deeply grateful to him. I would also like to thank the staff of Duke and the journal coordinators for all of their assistance, and I would also like to thank our staff editors who were helping us behind the scenes to put this on. And lastly, I would like to thank our managing editor, Aaron Malone-Smola, and our special projects editor, Matthew Sloan, who've done all of the heavy lifting to put this together, and so they deserve our deepest thanks as well. And with that, I suppose I could say, let us go and make justice great again. But in all seriousness, this is just the beginning of the story and not the end, and we all have a part to play in that. So thank you all for coming out, and we look to see you again very soon.